All right, so let's dive into something that I think affects a lot of us here in California.
Yeah.
Renters' rights. We've got guides and FAQs, even legal timelines.
Wow.
All about, what happens when your rental situation goes sour.
Yeah.
We're talking, peeling paint, rogue cockroaches, maybe even discovering your place is technically illegal.
Yeah. What's fascinating about California is how much power the law actually gives tenants.
Right.
It goes way beyond just getting the landlord to fix a leaky faucet. It really gets into what makes a place truly livable.
Right.
And what you can do when it's not.
Exactly. And I think a lot of people just assume it's, major damage, like a collapsed ceiling or no running water.
Right.
But our sources are revealing a whole world of uninhabitable conditions that go way beyond the obvious.
Yeah, the legal standard is not just about immediate danger.
Right.
It's also about things that impact your health and safety or the overall habitability of the place.
Okay.
So while that avocado green fridge from the 70s might be an eyesore, it's probably not grounds for legal action.
Okay, so bad taste isn't illegal, thankfully. But where does the law draw the line?
Right.
What are some examples that surprised you?
Well, one that stands out is the issue of insufficient trash facilities.
Okay.
So if the provided bins are constantly overflowing, attracting pests, creating, really unsanitary conditions,
Wow.
that can actually be considered a breach of habitability.
Really?
Similarly, missing locks on ground floor windows, even if nothing has been broken into yet,
Right.
can create a valid safety concern.
It's like the law recognizes that feeling of vulnerability.
Yeah.
Not just actual harm.
Exactly.
So it's not just about what's broken, but also what makes the place truly livable. And that's where things get really interesting.
Yeah.
Because California law gives tenants several powerful options.
It's almost like having a toolbox of legal remedies, each kind of designed for different situations. But here's the crucial point, just like any tool you need to know how to use them correctly. Otherwise, you might end up doing more harm than good.
Yeah. And that's where our deep dive comes in.
Right.
We'll break down each of these remedies, explain the risks and rewards, and give you the knowledge to act confidently.
Yeah.
So based on the source material, there seem to be 4 main options.
Yeah.
Moving out immediately, calling in the inspectors, that intriguing repair-and-deduct strategy,
Right.
and the nuclear option of withholding rent.
Right. Let's start with the most drastic one, moving out due to uninhabitable conditions.
Okay.
This is essentially saying the situation is so bad, I'm invoking my right to leave now without the usual 30-day notice.
Right.
But there are very specific conditions that must be met.
Yeah, the source really hammers home the importance of documentation here.
Yes.
It's not enough to just storm out in frustration.
Yeah.
You need to build a case that will hold up if
Yeah.
challenged.
Exactly. Imagine a judge reviewing the situation weeks later.
Right.
They weren't there to see the overflowing trash or the broken window lock.
Right.
What they will see is your evidence. Did you call the landlord first?
Right.
Did you send a formal letter listing the defects?
Okay.
Did you take detailed photos?
It's like prepping for a legal battle just in case.
Right.
And speaking of battles, what about calling in those reinforcements, the building and health inspectors?
Yeah.
What kind of power do they have?
So think of inspectors as having the authority to make your landlord's life very difficult.
Okay.
And rightfully so if they're neglecting their duties.
Right.
Building inspectors will focus on structural issues and code violations, while health inspectors will handle things like infestations, mold, and other hazards.
So it's not just about getting things fixed. It's about having an official entity hold the landlord accountable.
Exactly. A citation from an inspector puts real pressure on a landlord.
Okay.
They now have a deadline, potential fines,
Sure.
and the risk of even bigger trouble if they ignore the issue.
Our source material actually details some fascinating consequences.
Yeah.
Like Los Angeles' REAP program, where the city can literally take over management of a severely neglected building.
That's a powerful example of how seriously California takes tenants' rights.
Wow.
But it also highlights the need for proper procedures.
Right.
Even with inspectors on your side, documentation is still crucial to support your claims.
All right, let's move on to the repair-and-deduct strategy.
Okay.
This one sounds almost too good to be true.
Yeah.
You can essentially become your own landlord, at least temporarily, to fix habitability problems.
The source dives deep into this, and it's full of fascinating details.
Yeah.
You can deduct up to 1 month's rent for repairs.
Yeah.
But here's the kicker. You can do it twice in a row.
What?
So theoretically, you could fix up to 2 months' worth of problems.
Wait, hold on. Does that mean I could end up living rent-free for 2 months?
Not quite. There are some important caveats.
Okay.
First, you must give the landlord a reasonable time to fix the issue themselves.
And that's where things get tricky, right?
Yeah.
What exactly constitutes reasonable time isn't clearly defined, which opens the door for potential disputes.
Precisely. The source actually shares a story about a landlord who was notorious for ignoring repairs and raising rents.
Yeah.
He ended up facing a wave of repair-and-deduct actions from tenants who had finally reached their breaking point.
It's a reminder that these rights exist for a reason. Tenants shouldn't have to live in unsafe or unbearable conditions.
Right.
But using those rights effectively requires knowledge, careful documentation, and a clear understanding of the process.
Now let's talk about the final weapon in the renter's arsenal, withholding rent.
Okay.
This is a high-stakes option,
Right.
and it's only legal under very specific circumstances.
This is something you do lightly, right?
Absolutely not. It's a legal strategy that should only be considered in extreme cases and with proper legal guidance.
Okay.
We'll dive into the specifics of when and how to withhold rent in the next part of our deep dive,
Okay.
along with potential risks and rewards.
So stay tuned, folks. We're about to unlock even more knowledge
Yes.
and empower you to navigate the complex world of renters' rights in California.
Absolutely.
Welcome back to our deep dive into California renters' rights.
Yeah.
So we've laid the groundwork, but now it's time to get into the nitty-gritty of that last resort option,
Okay.
withholding rent.
Right. It's the nuclear option for a reason.
Yeah.
It's legal in California, but only under very specific circumstances.
Right.
And the burden of proof rests squarely on the tenant's shoulders.
So it's not enough to just be annoyed with the landlord.
Yeah.
You need a rock-solid legal justification.
Right.
So our source material outlines two main scenarios where withholding rent might be permissible.
All right.
The first is if the rental unit itself is an illegal structure.
Right.
Think, a converted garage that was never permitted for residential use, or an extra bonus room added on without following building codes.
Right.
In these cases, California law might prevent the landlord from collecting any rent.
That's pretty significant.
That's a pretty powerful argument for tenants.
Yeah.
But how do you actually prove a unit is illegal? It's not like landlords advertise that sort of thing.
Right. Well, the source suggests a few strategies.
Okay.
One is contacting the city's building department and requesting a copy of the certificate of occupancy for the property.
Okay.
This document outlines what the building is legally allowed to be used for.
So if the certificate says single-family dwelling, but the landlord has squeezed in 3 extra units,
Right.
that's a pretty clear red flag.
Exactly. You might also find clues in the lease agreement itself.
Okay.
Does it accurately describe the unit you're renting?
Right.
Are there discrepancies between what's on paper and the reality of the situation?
It's like playing detective,
Yeah.
piecing together the evidence. But even if you prove the unit is illegal, withholding rent is still a risky move.
Absolutely. You need to be prepared to defend your actions in court.
Right.
And that's where meticulous documentation becomes your best friend.
Oh.
Photos, correspondence with the landlord. Even notes from conversations, it all adds up to a stronger case.
So illegal units are one scenario.
Right.
What's the other situation where withholding rent might be justifiable?
So the second scenario is when there's a substantial reduction
Okay.
in the habitability of the unit.
Okay.
And this is where things get a bit more subjective because what's considered substantial can vary depending on the circumstances.
The source emphasizes that it's not about minor inconveniences.
Right.
It's about issues that significantly impact your health, your safety, or your ability to reasonably live in the unit.
Exactly. Think major plumbing problems
Okay.
that leave you without running water for days.
Wow.
A severe infestation that the landlord refuses to address.
Right.
Or even ongoing noise or disturbances
Yeah.
that make it impossible to sleep
Right.
or enjoy peace in your own home.
It sounds like a tough standard to meet. How would a judge determine if the reduction in habitability is truly substantial?
That's where legal precedents and case law come into play. A skilled attorney can analyze your specific situation,
Right.
compare it to similar cases, and build a compelling argument to support your claim.
So while withholding rent might be a legal option, it's not something you should attempt without professional guidance.
Precisely. Now let's shift gears and explore another key aspect of renters' rights.
Okay.
Calling in the inspectors.
All right.
This can be a powerful tool to hold landlords accountable, especially when they've been ignoring your pleas for repairs.
It's like bringing in the big guns, but how does the process actually work?
So it starts with identifying the right agency.
Okay.
Building inspectors handle structural issues and code violations. So they're your go-to for things like faulty wiring, unsafe balconies, or lack of proper heating and ventilation.
And for issues like infestations, mold, or sanitation problems, we call the health department, right?
Exactly. Both agencies have the authority to inspect rental properties.
Okay.
And issue citations if violations are found.
And these citations carry real weight.
They do.
What kind of consequences can landlords face if they ignore an inspector citation?
So the penalties can range from hefty fines to even criminal charges in extreme cases.
Wow.
But even beyond the legal repercussions, an inspector's report can be a powerful piece of evidence in your favor.
Right.
If you decide to pursue other legal remedies.
It's like having an official confirmation that the issues you've been reporting are legitimate.
Right.
And that the landlord have been neglecting their responsibilities.
Exactly. And in some cases, the city or county might even step in and make the repairs themselves.
Really?
Billing the landlord for the cost. That's what happens under the REAP program we mentioned earlier.
That's a pretty strong incentive for landlords to address the issues promptly. But calling the inspectors isn't always a guaranteed win, is it?
Unfortunately, inspectors can't force landlords to fix every minor problem.
Right.
And they typically focus on issues that pose a direct threat to health and safety.
Okay.
So a cracked window pane or a leaky faucet might not be enough to trigger a citation.
And sometimes landlords find ways to skirt the system, making cosmetic fixes that don't really address the underlying problem.
Exactly.
So it's really important to be vigilant and persistent.
Yes.
Document every interaction with the inspector, take photos of the violations, and keep pushing for a resolution, even if the initial inspection doesn't lead to immediate action.
Right. It's a reminder that navigating the world of renters' rights often requires patience, persistence, and a healthy dose of skepticism.
All right, now let's move on to a strategy that gives tenants a bit more control over the situation.
Okay.
The repair-and-deduct remedy.
Right.
This option allows you to take matters into your own hands when the landlord fails to address habitability issues promptly. This one sounds almost too good to be true. Are you telling me I can play landlord, fix the problems myself, and deduct the cost from my rent?
Essentially, yes. But like all legal remedies, there are specific rules and procedures that must be followed to protect yourself.
Okay, let's break it down. What are the key steps involved in the repair and deduct process?
So first and foremost, you must give the landlord written notice of the problem.
Okay.
And a reasonable opportunity to make the repair themselves.
And there's that tricky phrase again, reasonable opportunity. How do we define what's reasonable in this context?
Well, it depends on the nature and severity of the problem.
Okay.
A burst pipe that's flooding your apartment obviously requires a much faster response than a chipped tile in the bathroom.
So common sense plays a role, but I imagine there's also some legal interpretation involved.
Absolutely. A judge would consider factors like the urgency of the repair, the availability of qualified contractors, and any communication between you and the landlord regarding the issue.
So it's not a free pass to just go rogue and start fixing things without proper notification.
Not at all. You need to build a strong case that shows you acted reasonably and followed the proper procedures.
And that brings us back to documentation yet again.
Exactly.
We need to document everything.
The initial notice to the landlord, the landlord's response or lack thereof, any attempts to schedule repairs, and ultimately the decision to hire a contractor ourselves.
And don't forget to keep receipts for all expenses related to the repair. These will be crucial if you need to deduct the cost from your rent.
Okay, so let's say we've jumped through all the hoops, hired a licensed contractor, fixed the problem, and have a stack of receipts. How much can we actually deduct from our rent?
So the limit is 1 month's rent. But as we discussed earlier, you can use this remedy twice in a 12-month period. Meaning you could potentially deduct up to 2 months' worth of repair expenses.
That's a significant amount of money. It seems like a powerful incentive for landlords to take those repair requests seriously.
It certainly is, but there are still some potential pitfalls to be aware of. For example, if the landlord disputes the cost of the repair or argues that you didn't give them a reasonable opportunity to fix it themselves, you could end up in a legal battle. So while repair and deduct can be a valuable tool, it's not without its risks. We'll delve deeper into those risks and potential defenses in the final part of our deep dive.
We'll also explore some proactive strategies tenants can use to avoid reaching the point where drastic measures like withholding rent or repair and deduct become necessary.
Stay tuned, folks. We're about to equip you with the knowledge and strategies to navigate the complex world of renters' rights in California with confidence and peace of mind. Welcome back to the final part of our deep dive into California renters' rights.
Yeah.
We've covered a lot of ground from, the nuclear option of withholding rent to the strategic power of calling in inspectors.
Right.
But now let's shift gears and talk about how to be proactive.
Okay.
And avoid those high-stakes situations in the first place.
That's a great point. Prevention is always better than cure.
Right.
Especially when it comes to renters' rights.
Yeah.
And one of the most effective ways to prevent problems is to thoroughly document the condition of the unit.
Before you even move in.
That makes sense. How detailed do we need to be?
Right.
We're talking full-on CSI level photography here?
It doesn't need to be that extreme.
Okay.
But the more thorough you are, the better.
All right.
The source material recommends taking photos and videos of every nook and cranny, paying close attention to any existing damage, no matter how minor.
So, scratches on the floor, stains on the carpet, chipped paint. It all gets documented.
Exactly. And don't forget those often overlooked areas, like closets under the sinks, inside appliances.
Right.
You might be surprised what you find lurking there.
And what's the purpose of all this documentation? Is it just to protect our security deposit?
It's about establishing a clear record of the unit's condition at the start of your tenancy.
Okay.
This can be invaluable if a dispute arises later on regarding damage or repairs. If the landlord tries to blame you for something that was already there, you'll have the evidence to refute their claim.
It's like building a legal shield around yourself from day one. Right.
But what if we discover problems after we've moved in?
Okay.
What's the best way to communicate those issues to the landlord?
The key is to be clear, concise, and professional.
Okay.
The source material recommends putting everything in writing.
Got it.
Whether it's an email, a letter, or even a text message.
Okay, so no more casual, hey, the sink is leaking, phone calls.
Right.
We need to document the date, the specific issue, and our request for repair.
Precisely. And keep a copy of all correspondence for your records.
Right.
This creates a paper trail that can be helpful if the issue persists or escalates.
But what if the landlord ignores our requests?
Right.
Or drags their feet on making repairs? What are our options in those situations?
Well, we've already discussed some of the remedies available to tenants, like repair-and-deduct or calling in the inspectors.
Right.
But before resorting to those measures, it's often worth trying to negotiate a solution with the landlord directly.
So instead of immediately jumping to legal action, we could try to have a conversation, explain how the issue is impacting our ability to live comfortably in the unit, and see if we can reach a mutually agreeable solution.
Exactly. And sometimes a simple reminder of the landlord's legal obligations can be enough to get things moving.
The source material actually highlights some strategies for effective negotiation.
Oh, yeah.
One is to focus on the facts and avoid emotional language.
Right. Instead of saying, I'm furious that you haven't fixed the leaky roof, try saying, the leak is causing water damage to the ceiling and I'm concerned about potential mold growth.
Right.
I need this addressed promptly to ensure the habitability of the unit.
It's about presenting a clear, objective case that highlights the severity of the issue and the landlord's responsibility to address it.
Another helpful tip is to offer solutions rather than just complaining about the problem.
Okay, so instead of just saying, the oven is broken,
we could say, the oven is broken, and I found a reputable appliance repair company that can fix it for a reasonable price. Would you be willing to authorize the repair?
Exactly. By presenting a solution, you're showing the landlord that you're proactive and willing to work collaboratively to resolve the issue.
But what if negotiation fails and the landlord remains unresponsive? What are our next steps?
That's when we start exploring those more formal remedies we discussed earlier. Contacting the relevant city or county agency to request an inspection, or considering the repair-and-deduct option if the issue meets the legal requirements.
And, of course, we always have the option of seeking legal advice from a qualified attorney specializing in renters' rights.
Absolutely. Consulting with an attorney can help you understand your rights,
Right.
assess your options, and navigate the legal process effectively.
So the key takeaway here is that knowledge is power.
Yes.
By understanding your rights, being proactive, documenting everything, and communicating effectively, you can create a more positive and empowered rental experience. And remember, a well-maintained rental property benefits both the tenant and the landlord.
Right.
By working together and understanding each other's needs, we can create a more harmonious and mutually beneficial living environment.
That's a great point to end on. We hope this deep dive has equipped you with the knowledge and confidence to navigate the world of renters' rights in California.
Remember, you have rights, you have options.
Yes.
And you're not alone in this journey.
Thanks for joining us on this deep dive. And remember, knowing your rights is the first step toward protecting them.
Call now 714-442-9741. Thank you.